Welcome to BRR Legal Brief, looking at the top legal issues affecting corporate Australia this week. Today we're talking about the now infamous Qantas dispute, and joining us to discuss today is Gerard Phillips. He's a partner in the Middletons Workplace Relations and Safety team here in Sydney. Thanks for joining us, Gerard.
Pleasure.
Gerard, if we can just start, the Qantas dispute, 21 days of negotiations between the airline and the unions has come to a head on Monday. Where to from here?
Well, David, two things can happen from here. One, that period can be extended for a further 21 days, but in all likelihood what will happen is that Fair Work Australia will allocate a hearing date for the arbitration of whatever issues are outstanding. So there will be a hearing at some stage either later this year or more likely early next year to bring this to a conclusion.
Well, talking about those issues, what issues are up for grabs?
Well, probably the main issue is the security of employment issue, and that is the one which seems to have the greatest disputation between the parties. I mean, there's some other issues regarding money and things like that, but from what I can see from what the parties are trying to do is that they're trying to get agreement on as many issues as they can before the arbitration on the outstanding issues will take place. But it is that security of employment issue which is the killer.
What outcomes are you expecting on that issue?
Well, it's an interesting issue because the law over a long period of time would say on an issue like that, that sits fairly and squarely within the realm of managerial prerogative. So how the business will conduct and manage itself. There's a lot of thought about whether or not people should be actually able to bargain for something like that because, for God's sake, who gets security of employment? So if one was looking in cases decided in the past and for guidance there, one would say if that's found to be a matter within managerial prerogative, well, the employer could expect to prevail.
And of course, we've seen the pilots' union take action to, appeal Fair Work Australia's order to terminate the industrial action, and the remaining two unions are potentially likely to follow suit. The pilots' union hearing is due to be heard on the 1st of December. So with that in mind, how could that all affect this dispute?
Well, it could affect the dispute in this way because if they get up, it means there won't be an arbitration. It will mean that the unions can once again turn on their protected industrial action, which I think in the case before Fair Work, when they terminated the industrial action, the losses were something like $70 million. So coming into a peak holiday season when a lot of people would be flying, you could expect there'd be significant losses to Qantas. But the protected industrial action, which they want to be able to resume, is the weapon of choice, particularly by unions in the process of negotiating for an EBA. And once you remove that, they feel that they actually have little or no coercive power on the employer in those negotiations.
We'll certainly keep an eye on how things work out in that regard. But this has been in the press. It's been a headlining thing. Thousands of people have been affected by this dispute. So looking at the bargaining laws in general, does this highlight a need for reform, or are the bargaining laws actually working?
Well, in fact, the bargaining laws are not working. And the reason why we're seeing all these disputes now, not only with Qantas but with the nurses in Victoria, is that a lot of agreements which were actually made before the Fair Work Act commenced are now expiring. And so in many respects, the federal government's been inoculated from the effects of its own law for the past few years since Fair Work commenced, but these laws don't work. And they don't work for this reason. During the context of bargaining for an enterprise agreement, if you can take protected industrial action, so you get your troops to vote to take protected industrial action, it effectively becomes legally sanctioned extortion. So instead of being good faith bargaining, which is what it's meant to be, you've got one party, usually the unions, being able to wreak economic havoc on the employer. Now, employers much smaller than Qantas, so if you're someone in the suburbs of Sydney here who can't make out the things that Qantas did, you either suffer the losses and continue suffering the losses, or you give in. Most people give in. And so just from that point alone, the bargaining laws are not working. And if you look at this, if Fair Work did not make that order, under the law as it is, there would be no arbitration hearing to bring it to an end. And it's one of the things I find most curious in this whole Qantas thing. Here you are having one of Australia's big employers racing to the federal tribunal to say, please arbitrate this matter, when in the past it'd normally be the unions. And here in this case, the last thing the unions want is an arbitration hearing, because then their weapon of the protected industrial action, which just bleeds the employer's money, is no longer any use to it. So it's, in some respects, the world's gone mad, because 10 years ago, the situation would have been completely reversed. I actually think that you do need to be able to have an arbitration at the end of your bargaining if you can't get there. At the moment, it's not compulsory. I think if they're going to review this, there needs to be that element that you've got this set period to bargain. If you can't reach an agreement, then that dispute is settled in court, and it'll be like any other commercial dispute. If you can't reach agreement, there's a court somewhere who'll hear what you've got to say and reach an end to it. The fact that it's industrial relations shouldn't mean that the rules should be different.
Well, I'm sure a lot of people in the business community would probably agree with you there. Legally protected extortion, I like that as a line, and we'll see how things turn out in the political landscape. We'll leave it there for now, and thank you again for your time today, Gerard.
Thanks, David.